So our class today, Property Management Update on Laws and Rules. Our speaker is Adrienne Harrell. She is the president of Newbridge Management, which is a real estate investment firm in Turlock. She's worked as a real estate broker in Turlock for 15 years, concentrating on portfolio management. Adrienne serves as the 2020-2021 president-elect for the California chapter of National Association of Residential Property Managers and served as a secretary of the Turlock Council of CVAR for 5 years and hopefully will be returning. We're excited to have her here speak to us about some of the current changes and laws regarding property management. During the presentation, go ahead and type out your questions in the chat room. And when she's done, I'll read off your questions to her, or you can hold off on your questions. And during the Q&A, you're welcome to turn on your mic or camera or both and ask the question yourself. So let's get started. Please welcome Adrienne Harrell.
Thank you, Alvina. I appreciate the opportunity to be here and to talk to everyone about some of the things that are going on about the real estate and property management world. I do want to say that I am not an attorney, although sometimes I play one on TV, not really. But this is about 15 years of property management experience. My world is property management side of the real estate realm. And these are some of the things that we continue to see a lot of property managers make mistakes on and get into trouble with the Department of Real Estate. So if you are going to be going into property management, or that if you are currently in property management, I always recommend that you speak to an attorney and have an attorney that you can confide in and ask questions of, because the real estate laws, as we know it since January 1, 2020, have constantly been changing. It seemed like on a daily basis, everything was changing. So I recommend that you guys definitely consult with an attorney at any given point in time. The way that I'm going to be talking about property management today is I'm going to give you an overview of California and how it is that we're becoming a renter state. And then I'm going to delve into the different aspects of it. I'm not going to be covering every aspect of property management, just some of the things that are going to be important that you need to make sure that you address. The other thing that I'm going to say, please note, the Department of Real Estate in California is currently conducting virtual audits. So if you are an agent who is doing property management without your broker's knowledge and authorization, stop. Stop right now, because the fines are very, very hefty. Losing your license is not worth it, and your broker is not going to appreciate losing theirs. So having said those disclaimers, here are a couple of resources that I would recommend you utilize at any given point in time. By the way, this presentation is being recorded and it will be made available to you at a later date. I will not be providing my slides just because I want to make sure you don't say, oh, well, Adrienne said, and just because I'm not an attorney, I'm not going to provide my presentation slides to you. These are just informational for you to know, but the video will be available if you have any other questions. KTS Law Firm is a great place that provides articles and legal alerts. It's kts-law.com. Another great place to get some information on property management is the California State Legislature. We have their link there. California Apartment Association is a wonderful place to turn to. Mark Gavin with Stanislaus Mediation and Project Sentinel is a great guy, and he is always available to answer any and all questions. And of course, I'm happy to always answer questions. My email address is adrienne@newbridgemanagement.com, and you're more than welcome to give me a call or drop me an email at any time, and I'll be happy to help out any way that I can. So let's dive in. How did we get here? In the state of California, the peak of housing affordability was in the second quarter of 2012. We all know that the real estate market kind of crashed and did a nosedive in about 2008. And so although the real estate market crashed, that meant that the prices and the affordability of the homes went up. So more and more Californians would have been able to purchase a home in the second quarter of 2012. Since then, it has tapered off and it has come down. As you can see from the slide is that about the affordability rate was a little bit over 70%. Put another way, more Californians could buy homes for after 2008 till about 2012 than they could today. Today, only about 33% of Californians can afford to buy homes. So if you look at how we compare across the board in the US, single family homes, condos, in the US, today only about 57% of the population can afford to buy homes. In California, that number is only about 33%. Whereas when we talked about the housing affordability being high in the second quarter of 2012, 56% of Californians could buy a home then. The largest metropolitan area closest to us, which is the San Francisco Bay Area, you can see that number even lower than the state average, which is only at about 28% of residents in the Bay Area can afford to buy homes. Having said that, let's take a look at what it takes in order to buy a home in California. So in 2012, your income would have only had to be about $56,000 in order to be able to buy a single family home within the state. That number has more than doubled by the second quarter of 2020. San Francisco Bay Area, all you had to make was $90,000 8 years ago. Today, $186,000 in order to be able to afford a home in the Bay Area. So if you look at those numbers, within the last 8 years, your income would have had to double in order to be able to afford a home anywhere within the state. 1960 was probably California's highest rate of home ownership. Since then, the numbers have gone down, and there was an upward trend in the 80s and the early 90s and 2000s. But since 2000s, we have seen a decline in the number of homes that are owned by Californians. That number right now is a little bit above, it's expected to be a little bit above 54% by the end of 2020. However, by 2025, that number is expected to go even lower. And according to the California Association of Realtors, by 2040, only 40 to 47% of Californians will be able to own a home. That means that properties are being taken off the rental market, and they are being, the more and more Californians are not able to afford their homes, which means that it is becoming a renter state. There's only about 40% of Californians that can afford to buy their homes and be home owners, the majority of them will become renters. And that's why we see a direct impact during the election years. During the last election cycle, one of the biggest items on the ballot was to overturn Costa-Hawkins. If you guys don't know about Costa-Hawkins, I've taught an entire class that is on our website. You're more than welcome to go take a look at it. But Costa-Hawkins kept the single family homes and any multifamily home that was less than 15 years old out of the rent control market. During the elections a few days ago, thankfully, Costa-Hawkins was not overturned, but we're not out of the woods just yet. So let's take a look at what's happening within the Central Valley. I do realize that there might be some people that are on this Zoom meeting from other areas, but I just chosen to concentrate on the local market within the Central Valley. So if we look up and down the 99 corridor and then work west towards the Bay Area, you'll see that the median price in the city of Merced is about $308,000 and 17 days on the market. That number jumps up to $378,000 with only 6 days on the market in Turlock. As we go further north, because there is a larger inventory available within the city of Modesto, and Modesto is much larger than Turlock, that number kind of goes down a little bit to 362,000 with only 6 days on the market. Stockton is about the same as Modesto is. However, as we take a look and we start moving west, we're looking at Patterson, which is on Highway 5, that number jumps to $415,000. Get ready for those numbers to change drastically. In Tracy, that number jumps to $542,000 within, and only on 7 days on the market. Mountain House, which is the very last exit on the 205 heading into the Bay Area, that number jumps to $700,000 with only 5 days on the market. And this morning during the CVAR meeting, someone shared that Mountain House for last month only had 1 property available on the market. So what that means for all of us as real estate professionals is that more and more individuals are buying the homes to live in them. So it reduces the amount of inventory that is available for renters, which makes it that much more challenging and that much more difficult to manage properties within the state of California. And property management companies and property managers are those that are being scrutinized even more than any other profession because of all of the issues that we have to deal with, not only in terms of housing, but trust fund issues, fair housing issues, and all of those things. So what that means for our area, so as our region, if we were to look at only across the West, it says 3.8% there's a 3.8% vacancy factor in the West Coast. If you were to ask me to tell you what it is here in the local area, I would say it's less than 1% vacancy rate. That means any property that is coming on the market today, it is being rented out within days. It doesn't even stay on the market an entire week. What that does is that it also provides a lot of opportunity for some individuals to think that, oh, well, we can get into the property management side of the world because, you know, as the real estate sales slow down, perhaps we can get into property management. And I highly encourage that, but I always say, make sure that your broker knows about this. So let's take a look at the property management and tenant rights. The governing laws that are focusing on tenant-landlord relationships are governed by federal laws, state laws, local ordinances, and court jurisdictions and court decisions. So basically the case laws. So when you're looking at considering managing a particular property or a tenant, understand that you're going to have to abide by everything. You can't just go by what is currently available in the local market. Fair housing is one of the biggest issues in the real estate. A friend of mine who is in Southern California this morning actually posted an article on LinkedIn. I'm going to do a shout out to Rick Alberts. He said that Redfin is getting into trouble because of discrimination or redlining. And so it is very important to make sure that you understand you cannot discriminate in sale or a lease of a residential property. There are 22 different items that you have to make sure that you cannot discriminate against. This is California. Basically, even if you're thinking about it, just don't. Race, color, ancestry, religion, national origin, gender identity, gender orientation, gender expression, physical or mental disability, familial status, source of income, citizenship, primary language, immigration status, military or veteran status, age, criminal history. You cannot discriminate. None of those things can come into play. I'm going to talk about the source of income just for a second. And that's because a lot of people always say, well, I do have a property that I want to rent, but I don't want to have any Section 8 tenants. Well, that law changed this year. Previously, you could have said, I don't want to work with Section 8 tenants. But as of this year, that is considered source of income. You cannot discriminate to tenants whose source of income is Section 8. The other thing that I want to address on this list is criminal history. It used to be that people would say, well, I'm not gonna rent out anything to any criminals. The law looks at things a little bit differently. If an individual has paid their debt to society and has done their time and has paid their fines, therefore you can no longer discriminate against them. So make sure that you understand that you cannot discriminate on someone based on criminal history. What does it mean to be in violation of fair housing? That's to refuse to rent to anyone after you have made an offer. A lot of companies or a lot of individuals are starting to think that, well, we can do our negotiations online. Tenant sends me an email, they send me their application, but then you review their application and you look at where they are and you say, okay, we're gonna go ahead and extend the lease to you. But then once you meet them, you change your mind. You cannot do that. That's a violation of fair housing. You can't not negotiate it after you have made a fair, good faith offer to that individual. I've seen individuals do this. They're working in the property and they've decided to make an offer to a prospective tenant. The prospective tenant shows up and they see them for the first time and they think, oh, you know what? The property is no longer available. I'm sorry. While it looks like it is being available. You cannot discriminate in advertising. For example, you can't say no kids allowed in this property. I still am amazed that people say, yeah, I'm gonna go ahead and rent my property out, but I don't want any kids living in my unit because they're just gonna destroy my house. You cannot discriminate. That's considered discrimination based on familial status. You can't coerce, intimidate, or threaten tenants' rights. So if you find out that someone may have immigration issues, you cannot tell them that if you don't do this, then I'm gonna call INS. That's coercing or intimidating or even threatening a tenant that is in the property. So in general, you just cannot discriminate against anyone, even the facilities. I'm gonna go back to the kids. If you have a swimming pool and say, you know what, your kids can't use the swimming pool because they just make too much noise and I just don't want the kids in there, that's considered discrimination in terms of providing the services. So you have to be very careful when it comes to that. When you're starting out your relationship with a tenant, it's always a good idea to get an application from them. Any individual, I will tell you, any individual who is over the age of 18, you should have them submit an application because you want every legal person that is going to be living in the property to be listed on the lease. Emancipated minors should submit their applications. In today's world, you can charge as much as $52.46 for an application. If that's your cost, then go ahead and charge that, but make sure that that is your cost. When accepting applications, you have to provide a receipt for that application. A lot of individuals right now are working with various online applications and companies and software companies that automatically provides them with a lease. For example, we utilize Appfolio. Appfolio automatically provides the lease to the tenants when they submit their applications. If you do not screen a tenant, you have to refund them their application fee. There are individuals that'll say, oh, well, you know, I'm gonna collect all of these applications and then I'll screen all of them and then I will make a decision. Let's say you collect 5 applications and you only screen 3 and you decide that you're gonna go ahead and make have someone, the third applicant, the offer to lease. The last 2 individuals whose application you did not screen, you have to refund them their money. You cannot hold that. In your application process, these are the things that you can screen for. And you should have a standard so that way you are not discriminating against anyone. Credit standards, rental history, employment verification, past eviction, and criminal background. Now, I will tell you that you have to be careful with the criminal background because you cannot discriminate against an individual because they might have a criminal background. You have to understand that. When you're accepting a lease and you're offering a lease to someone, you let the tenant know that, or the prospective tenant know that you're going to go ahead and offer to them. But if you elect to deny or conditionally accept an application, you have to let the person know. If you're going to be denying the application, you have to have legal reasons. It can't be just because I didn't like your purple hair and your green tattoos or your piercings. It has to be a legal reason. And that's why in the previous slide here, I said, make sure that you have credit standards. If you're going to say across the board that I'm not going to rent to anyone with a credit score less than 675, then that's the standard that you use across the board. You don't deviate from that, okay? Or if you have a conditional acceptance, for example, you say, okay, I'm gonna go ahead and not accept anyone with a credit score of less than 675. However, if they have double the security deposit, I'm going to rent to them. Or if they have the cosigner and their cosigner is a California resident with a score of above 700, then that's a conditional acceptance. So you can have conditional acceptance, but you can't just make it arbitrary. It has to be the same across the board. When you do deny an application based on credit, you have to give the tenant the name of the credit reporting agency where you got the their credit report from. You don't have to necessarily provide the credit report itself because you're not a credit reporting agency, but you do have to provide the agency from where you receive that. If you have other factors as to why you're denying an application, you need to let them know that too. Not too long ago, we ended up denying an application for someone because they had forged their pay stubs. And when we called the company to verify their employment, they said, yeah, that individual hasn't worked here since last year. And we called them and said, you know, we're sorry, we're not going to accept your application. The person became very incredulous. And we said, look, you forged your pay slips. There's a reason why we denied your application. So you have to let them know if there are other factors as to why you are denying somebody's application. Leasing. So once you go through the application process and you offer someone a lease, you can either do a written or an oral lease. I do not recommend having an oral lease because you want to document everything. Always have a written lease, just to cover yourself. In the written leases, you should always have the names of all of the residents. Earlier, I said make sure that anyone over the age of 18 submits an application. This is where you put in all of their names. If they have any children, you also put their names on the lease in a section where it says children. They don't have to be a responsible party, but I would recommend that you have all of the kids' names in there too, because sometimes during the term of a lease, a child may become an adult. So you want to make sure that you have everyone's names on there. You want to make sure you have the address of the premises where the lease is going to be at. The terms of the lease. How long is this going to be? Is this going to be a 1-year lease, a 6-month lease, or a month-to-month lease? And put in there whether you're going to be extending the lease after the 1 year or not. Make sure that you have the amount of the rent in there. How much are you going to be charging for rent? This next point, subject to AB 1482, is very important. You have to let the tenant know whether that property falls under the Assembly Bill 1482, which talks about rent control. Is this property under rent control? Single family homes, condominiums are not under rent control. There is a caveat to that, unless it is owned by the Real Estate Investment Trust, and there are exceptions. So make sure that you know whether the property falls under rent control or not. And again, I will say that I'm not going to go too much into detail on that. I do have a video on our website if you want to take a look at it. It's free for you. Make sure you put on their security deposit. How much is your security deposit? Is it twice the monthly rent, or is it one time the monthly rent? Know that as of this year, if you are renting to a service member, you cannot charge more than 1 time the rent for security deposit or 2 times the rent for furnished properties to service members. Anyone else, you can charge them 2 times the rent for security deposit for unfurnished, 3 times for furnished properties. Payment information, you want to make sure that you have that in there and have a physical address. Nowadays, a lot of people just give an account number and say, hey, go ahead and deposit the funds into this account. That's fine, but you also have to provide a physical address as to where that person can come and drop off the rent to you. Always have your phone number on there. Make sure that you sign the leases. Everyone that is financially responsible signs the lease, and then provide a copy to the tenants. Just like in real estate, whenever you have a purchase agreement, you provide a copy to them. Make sure that you provide a copy to the tenants as well. You should always have the termination terms in the lease as well. So if you're going to be terminating the lease, who's going to be responsible for cleaning the property? If it's normal wear and tear, of course, it's the owner. But if it has to be cleaned, then that's the tenant who's going to be responsible for that. Always have limitation of liabilities. If someone that rents a two-story home and a tenant goes down the stairs and happens to fall down the stairs and breaks an ankle, heavens forbid, you don't want to be liable for that. So always have limitation of liability clause in all of your leases. Let the tenant know who's responsible for the utilities. Is it you or is it the tenant? Is it, it used to be in our area, homeowners paid for water, sewer, and garbage. No longer. Or today, a lot of them want to pay a certain portion of the utilities. There are certain cities, for example, the city of Elk Grove, city of Denair here locally in Stanislaus County, they will not allow tenants to put the utilities, water, sewer, and garbage in their name, because during the real estate crash, a lot of those utilities weren't being paid and the cities were left trying to figure out how to collect on these. So they are now putting liens against the properties if the utilities aren't paid. So make sure that you identify who is responsible for utilities. If you always have military personnel clause in there, that's important, because if you have military personnel that are renting your home and all of a sudden they are being called to active duty and they have to leave, you have to let them out of the lease because they have their orders. So make sure that you have a clause in there. Access for inspection is very, very important. You want to make sure that you let tenants know that with a 24-hour written notice, you can enter the premises. A lot of times people forget that and they say, well, my tenant won't let me go into the property. And I look at their leases and I think, well, you don't have access for inspection. You have to say how you're going to be accessing the property at any given time. Other things that you should have within your lease are talking about repairs and alterations. Who's responsible for the repairs and the alterations? And the important part about that is its financial responsibility. So if a tenant, for example, you have in your lease that you cannot make any alterations to the property, and the tenant decides that they're going to be painting one of the walls in the bedroom bright purple with yellow polka dots and green stripes, and then they move out, well, who's responsible to pay for that? Make sure that you have that information in there. That's an alteration. It wasn't allowed. Tenant did not have written authorization from you or the owner, and therefore they are now financially responsible. So make sure that you have that information in there as well. Other things to have in your lease are the late fees, non-sufficient funds, attorney's fees, termination fees, and concessions. What happens if your tenant decides that they're going to be leaving the property less than 1 year? Are you going to have early termination fees? Or if you tell them, look, if you move in on the 25th of the month, I'm going to give you free rent from the 25th through the 30th, but your lease starts as of the 1st. That's giving the tenant a concession. Make sure that you capture that, because if the tenant leaves the property early and in your termination agreement, you state that if they leave early, they owe you that money back, that should be in your lease. The other things that you should always have in your lease are your disclosures, which is the house rules. And this sometimes has some of the city ordinances, like, you know, the noise level can be a little bit louder from 8 a.m. until 10 p.m. Monday through Friday, but not after 10 o'clock. That's a city ordinance. It's part of the house rules. There's no smoking in the house. If there's any CC&Rs, if you're going to allow any pets on the property, or if you're not going to allow any pets, and if you are going to require renter's insurance from your tenants. One thing I do have to tell you about the pet agreement, the minute that they say they have a service animal or an emotional support animal, I don't care how much your owner says, I don't want a pet in my property. The minute they say they have a service animal or an emotional support animal, all bets are off. You have to allow them to move in. They have to be able to move in their animals. Now, I understand that a lot of people say, well, service animals are especially trained, emotional support animals are not. You're right, they're not. But emotional support animal, if someone comes up and says, you know what, my therapist said that I need this animal and here's a note, you have to allow them to bring in that animal. And you cannot require additional security deposit for that animal. So you can't even ask for a pet deposit. Some of the other disclosures that you should have on there are regarding your carbon monoxide and smoke detector, bed bugs, signage. We just went through a political process. You cannot not allow political signs. Political signs during the political season have to be allowed. Megan's Law, you have to let the tenants know that there is a database and that sex offenders have to be registered in that database. Crime-free disclosure. You want to make sure that your tenants know that no criminal activity will be tolerated at a property. An example of that is that I had a tenant who brandished a weapon against one of his neighbors. Police showed up and they wanted to go into the property. The tenant didn't cooperate. Next thing I know, the SWAT team shows up and has tear gas. They blew tear gas into the property and they ended up going in with force. He was involved in criminal activity. Based on that clause, I was able to evict this individual from the property because he engaged in criminal activity at the property. So make sure that you have a crime-free disclosure in there as well. And of course, in all real estate, if there's a death in the property for the next 3 years, you have to notify the tenant. If your property is older, was built before 1978 for lead, 1981 for asbestos, you have to let them know. You have to let tenants know if there was mold in the property and how to prevent the creation of mold within your property. It used to be that you only had to give them the tenant flood hazard disclosure when a property was bought and sold. Not so much anymore. You have to give them that same disclosure when they're renting. You don't have to give them the report, but you do have to provide where the information where they can get that information. So you have to give them the website and the URL. The last one is something that not a lot of people know about, which is the Violence Against Women and Department of Justice Reauthorization Act of 2005. This went into effect in 2005, and I cannot tell you how many property management companies do not put that information in there. It is to protect the victims of domestic violence. So make sure that you have that in there. And if you have for example, a Section 8 tenant who is been victimized and is a victim of domestic violence and they don't pay their rent and they don't say anything and you go to evict them from the property, guess what? That is going to protect them. So you have to make sure that you put that in there. If you have any restrictions on the property, make sure to know that in your leases about the barbecues, TV antennas. I don't think there's anybody that has a waterbed anymore, but you never know. Just make sure that it's in there. My philosophy is throw everything, including the kitchen sink, so that you're covered on everything. And I know that car forms are very popular. I personally don't like cars. I refuse to use cars because they leave way too many holes in there. I would highly recommend that you work with an attorney to come up with a lease that is going to make sense to you. So let's jump in real quickly in some of the other things that you have to know about. Rent control. So as of January 1, 2020, California became a rent control state. Now, here's the funny part about that. That law is supposed to sunset January 1, 2030. I don't think it's going to happen, especially since California is going to be becoming a renter state. More and more renters are going to be voting. So I doubt that law is going to go away, but it is a 10-year law that is supposed to sunset. It prohibits and limits certain fees, and it limits the amount and frequency as to how much rent can be increased on an annual basis. So if we look at the history of CPI, and I'll tell you why I'm talking about this, is that from about 1910 to about today, CPI has gone up it's at about 20%. But the change, overall change, where is that red? The percentage change in the last 20, 30 years, it's only been less than 3% up or down. So today, if you wanted to issue a rent increase, it has to be 5% plus index not to exceed 10%. When I first gave this class and this talk to people, Sacramento index was at 3.34%, which meant you could increase your rent at 8.34%. That has been dropped to 1%. You can only increase rents up to 6%. But now we're only talking about AB 1482. We have another law that we have to talk about, which is AB 3088. And then you do have to give the tenants notice when you're doing the rent increases. If they are not able to utilize certain services that they were previously doing, they may request a decrease. One of my friends, Ray, in San Francisco, is seeing the tenants request a decrease in rents because they're not able to utilize certain facilities within a property because of the coronavirus. They can do that. So if the services are reduced or the property is not maintained, know that the tenants can ask for a reduced rent. Along with rent control comes just cause eviction. So everyone talks about, oh, I wish we had rent control. I wish we had rent control because rents are going they're out of control. So they're just skyrocketing. What they don't realize that with rent control comes just cause eviction. And it prohibits the no cause eviction. It used to be you gave someone either a 30-day or a 60-day notice and they had to move out. Now you cannot do that, especially in a multifamily property. So let me clarify, anything that is more than a duplex, it now is considered a multifamily. Duplex that is not owner occupied on one side. Okay, so if you have an owner that is occupying one side of the duplex, the other side does not fall under rent control. But if you have a duplex that is not owner occupied, anything larger than that falls under the just cause eviction. And there are two reasons where you can do an eviction, which is tenant fault and no fault eviction. Tenant fault eviction, that means that if they're not paying their rent, or if they are in breach of their contract. For example, if you rented the property to 5 people and now all of a sudden you have 10 people living in there, that's a substantial breach of contract. That's why it's important to have all of those things in your lease agreement. If they conduct any illegal activity, or if that they're not allowing you access into the unit. Now, failure to allow access, I think that's a very touchy one because it's your word against the tenant. But you can actually evict tenant for non-payment of rent. That's probably your best bet. The no fault eviction, as a matter of fact, I was talking to someone today that wanted me to take over the management of 3 properties. And I said, yeah, you can't evict the tenants. And their whole thing was that we want these 3 tenants out because the rent is below market. And I was telling them that the only way that someone could get a tenant out of a property at no fault of the tenant is to either substantially rehabilitate a property, the owner moves in, or if the property is being moved off the market, or if it's being demolished. Now, rehabilitation of the unit, it doesn't mean that you can change the carpet and put a new coat of paint on there. That means that you have to significantly change how the property is, and you have to pull permits, and the work is going to take more than 30 days to rehab the property. And if the owner moves in, owner, their children, and their parents are the only ones that can move into the property, then you can give the tenant the 60-day notice. If they are a Section 8 tenant, 90-day notice. Or if the property is being removed off the market. One of the things I told someone yesterday is if you're going to be giving someone a 60-day notice today, make sure that in the reason there that you have that says, we are selling this property to someone who's going to be occupying the property, therefore removing it from the market, or the property is going to be demolished. Just yesterday, I noticed a couple of properties were being demolished here in Turlock on the corner of Golden State and Canal. For those people that are local, that's a good reason to give someone to get someone to move out at no fault of their own. Know that if you are doing a no fault eviction, you do have to pay the tenants to move out. One of the things about AB 1482 is the anti-price gouging. I'm not going to spend too much time on it, but it's triggered by the state of emergency within the state of California, and it doesn't limit it to the areas that it's in. It's all over the state. Just so you guys know, California essentially has been in one way or another in a state of emergency since 2017 because of all the fires and now because of the coronavirus. And just because one area is impacted, it doesn't mean that you can increase the rents elsewhere. So if the car complex fires a few years ago in Napa Valley destroyed a lot of homes, if any, that meant that the rest of the state could not increase their rents or increase the rents so substantially that people that were moving couldn't move into those markets. Now let's jump quickly into AB 3088 because that's the newest law that went into effect. So everything that we know about 1482 that I just briefly touched on, take it all, throw it out the window. I know that sounds weird to throw it out the window. It's because a lot of things really changed. And for a while there, it seemed like I would send out an update on Monday based on what was happening in state legislature on Friday, letting my owners know that, hey, these are the laws that are taking effect. By Wednesday, I had to send them another letter saying, oh, never mind what I just told you on Monday, everything just changed on Tuesday. So here we are. Things were very fluid in 2020. And as a result, on August 31st, the COVID-19 Tenant Relief Act of 2020 was enacted. And it basically provides protection against evictions for homeowners and tenants. I'm not going to touch the homeowners. I'm briefly going to be talking about the tenants. Essentially, what this law said is that you cannot evict a tenant for non-payment of rent if they have been impacted by the coronavirus. And it expanded the just cause eviction until January 2021. So before, if you could have given a tenant a 60-day notice and have them move out, now you can't do it, and you cannot ask them to move out before January 2021. And it expanded the small claims court, and I'm going to be talking about that. And whatever local moratoria that there were from in the local markets, such as in San Diego or Santa Monica or Los Angeles or San Francisco, it expanded those, and it provided for penalties for illegal lockouts. So getting into those a little bit deeper, today, if a tenant owns rent, you have to give them a 15-day notice for non-payment of rent. The 3-day notices that we used to give tenants to pay or quit, throw them out. You cannot use a 3-day notice to pay or quit. You now have to use a 15-day notice. If the tenant owes rent from March 1st through September 1st, that essentially is going to be considered a loan from the homeowner. And you cannot evict that tenant until March 1st, 2021. Rent from March 1st through September 1st is something that the owner has to take the tenant to small claims court. They cannot be evicted for that. Rent owed from September 1st through January 2021, that you can write them a 15-day notice for. So rent from March to September, the owner has to take them to small claims. And earlier I mentioned that small claims was expanded, and it used to be that an individual cannot go to small claims more than 2 times, and the maximum amount was $7,500. Well, that got expanded because the rents for those months is going to be more than the court limit, and an investor may have 4, 5, 6, or 7 tenants that they have to take to small claims. So that's how this law expanded those. Rent from September 1st, 2020 through January 2021, you can issue them a notice, but you also have to provide the tenant with the declaration of COVID distress. So if the tenant returns that declaration, which is an affidavit that says, under penalty of perjury, I have been impacted by the coronavirus and I cannot pay my rent, and I can only pay 25% of the amount from September through January, you cannot evict them. You cannot evict that tenant. So if their rent, this is just for example purposes, if their entirety of the rent from September through January was only $1,000, and they paid you $250 at the end of January, and they gave you that declaration that they have been impacted by the coronavirus, you cannot evict that tenant. If those conditions are not met, then you can move forward with an eviction. The just cause, I told you it was because of the at fault and no fault. So the no fault, it was extended. The at fault, it does limit what it is. Again, it's if the property has to be demolished or rehab due to health and safety. It can't be just, oh, I'm gonna remodel it. It has to be due to health and safety. Or if you're gonna be selling the property to an owner occupied, or if the lease ended before March 1st, 2020. So if you had a tenant whose lease ended February 28th, 2020, and then coronavirus, changed our world and the tenants were impacted and didn't move out, you could evict them after January 1, 2021. But their lease would have had to have ended and they should have given up possession before March 1st, 2020. As I said, there's small claim expansions that rent from March through January 2021 has to be taken, can be claimed in small claims court. It increases the amount of the small claims and how many times an owner can go into the property, and no cases will be heard before March 1st, 2021. So there are penalties for all of these things. The penalties, so if you go ahead and let's say illegally evict a tenant or you lock them out, then it's whatever the damages that that tenant suffered. So if they had to pay for all of their moving costs and everything else, you would be responsible for paying that plus $100 a day for every day that that tenant was impacted. The other penalties are on top of that, it's $1,000 to $2,500. And this will sunset on February 1st, 2021. My slides are a little bit out of order at this point, but this is another thing that I wanted to talk to you guys about in terms of right to enter into the property in your leases. You can only enter the property if there is an emergency at the property, if a tenant abandons it or surrenders it, if there's a court order. A friend of mine just last week told a property manager that they have to go into the property. And so if you are under court order, you can enter into a property. If the tenant calls you and says that I have damages to my property, or if there is a repair that needs to be done, and I want you guys to come in at such and such time, then you have an agreed appointment with them. And then also to show the property to prospective buyers and tenants. I always say, if you have to show a property to a buyer, go ahead and do it. But if you're gonna do it with a prospective tenant, it's best to wait until the property is vacant, because you just never know what situation you're gonna walk into with the current tenant when you're walking in a new prospective tenant. The other reason why you can enter the property is to provide entry for contractors and to do an inspection for the property before the end of the tenancy. One of the things that a lot of people fail to do is inspections before a tenant moves into a property, or offer to do an inspection prior to someone moving out. So you have to, or you ought to, provide a tenant who gives you a 30-day notice, a written notice saying that you are in receipt of their 30-day notice and you are offering them a pre-move out inspection. That does two things. One, it lets you know how much work you have to do before the tenant moves out. And the other thing is it allows the tenant to know how much work they need to do in order to get that property turnover ready. So that way they know if their carpets, for example, you told them that their carpets had to be shampooed and they don't, and that it's going to get deducted from their security deposit, so that they are aware of it. It doesn't become as a surprise to them. The other reason why you may enter a property is to maintain their smoke detectors and their carbon monoxide detectors. The other thing that property managers tend to get into a lot of trouble is because of the security deposits. In your leases, make sure you let the tenants know who's responsible for cleaning, who's responsible for the damages, what happens with the unpaid rent, and what happens if they choose not to have a pre-move out inspection. These are some of the areas that some property managers tend to get into trouble with. I had a tenant who recently moved out. I think it was in February he moved out, and we charged his security deposit for cleaning the property and doing the carpet shampooing. And as soon as he got his disposition letter, he went ahead and served us with a suit in small claims asking for his money back. And so we had to show up in court, and we showed that, we had, before he moved in, carpets were shampooed, the property was professionally cleaned. We did a move-in inspection, took pictures of the property. Before he moved out, we offered him a pre-move out inspection, which he declined. And oh, by the way, here are all the texts and messages that we have documenting this. And when he moved out, we had to go back in and do the cleaning and carpet shampooing. And here are all of the receipts from before and after. The judge found in our favor and said, no, the tenant had to do that. And oh, by the way, it was in his lease that he was responsible for the cleaning upon move out. So make sure that you do that. Once a tenant gets ready to move out, once the tenant moves out and relinquishes possession of the property, you have 21 days to get them back that security deposit. No ifs, ands, or buts about that. 21 days. Your envelope has to be postmarked within that 21 days, or your last day is day 21. If you know your day 21 is going to fall on a Saturday or a Sunday, get it out the Friday before. Make sure you do that, because more and more judges are asking to see the post date on the envelope, and they're asking about that. So make sure that you get that done within 21 days. You have to provide an accounting of all of the funds that you are spending out of the tenant's security deposits. Be ready to provide that tenant with receipts. And if you withhold tenant security deposits, know that you are going to be held responsible for that. If you don't have actual costs, that's okay. You can give a tenant an estimate within that 21 days, but you have to be ready to provide that information. If you are a landlord and you're doing the work, make sure that you itemize everything and you provide for your time. The receipts that you are providing the tenant with that security deposit disposition should include the contractor's contact information. Now, if you get an estimate, for example, we have, we go in and we have to repair the ceiling fan, replace the light bulbs, and you get an estimate within that 21 days. You can send that estimate, but you have 14 days after that to make sure to do the actual work after that 21-day period. And if that estimate is lower than what you had received. So for example, if the vendor said it's $500, but it only ended up costing $450, you have to provide that receipt for $450 plus that additional $50 back to the tenant, saying that, here's your money within 14 days. And you have to send it to their last known address. Sometimes tenants move out and don't provide a forwarding address. Whether they do or not, and regardless of how much they owe you, you still have to send out that disposition letter within 21 days to their last known address. Because it has happened where tenants have come back and said, you know what, 21 days went and I never got a disposition letter. They don't tell you that they had a forwarding address. So, and you think, well, they never gave me an address, I'm not going to send it out to them. You're not off the hook. You still have to send that out. Now, the only time that you don't have to provide a receipt for work is if the work is less than $120 against the security deposit, or the tenant waives that right. Security deposit does not cover normal wear and tear. You have to keep that in consideration. If a life expectancy of a carpet is 10 years and a tenant has been living in there for 17 years, which does happen, you cannot charge them for the carpet at that point, you have to replace it and it's the owner's cost. So normal wear and tear cannot be deducted against the tenant security deposits. Damages can be. And whatever damages, make sure that you document them and have receipts for everything that is there. So with that, I think I'm 2 minutes early, and I'm just gonna go down to the Q&A section, and I'm sure there are a lot of them because I kept seeing things pop up. So Alvina, do you wanna take over, or are you gonna let them ask?
Okay, so thank you so much for that presentation. That was awesome. We do have one question so far, and I'll just read it out to you. So Rick Albert asks, you have to disclose whether the property is under rent control. Does that apply only to statewide rent control, or would that include local ordinances? For example, a single family home with an ADU isn't subject to rent control statewide, but is in Los Angeles.
You have to disclose you have to disclose whether the property does or does not fall under AB 1482. I understand that ADUs in many jurisdictions do not fall under rent control. That's fine, but you still have to let the tenant know, and it has to be in their lease, that this property does or does not fall under AB 1482. And as a matter of fact, on our leases, we have 2 sections, as our leases are our template. One says this property falls under rent control. The other says this property does not fall under rent control. And we just check the box on that. So make sure that you do have that language in your leases. So and especially if you're using a template lease for all of your properties, that way you can check mark whether it does or it does not. And if you have properties who already had leases before January 1, 2020, so for example, a tenant moved in 3 years ago, you have to notify that tenant whether that property currently falls or does not fall under AB 1482. You still have to disclose that, regardless of the local ordinance. I hope that answers it.
It did, thank you.
Adrian, I think you did such a good job that we don't have any more questions right now.
Well, that was easy. Everyone has my contact information. It's Adrian at Newbridge Management, and my office number is 219-668-6700. If you guys have any questions, please feel free to reach out to me. I'm happy to answer them offline.
Awesome. Thank you so much, everyone. Thank you, Adrian.
All right, thank you. Bye, everybody.